Hello and welcome to Political Capital, the show where Delhi meets the last street. I'm Webunar+, standing in for Webunar+. The Delhi High Court has made a landmark ruling on the issue of indirect transfer of the assets and their liabilities and taxation of the same. This ruling provides some clarity on the threshold limit that will be deemed substantial and taxable following the retrospective amendment in the 2012 budget. The Shom Committee recommendations, the new direct taxes code, has had different views on what really constituted as substantial. Our team of reporters, Priyal, Gaurang and Ashpreet, will get us all the details on the story. I will also be joined shortly by Sunil Jain of J. Sagar Associates and Shreya Rao of Nishit Desai Associates to discuss this issue further. Priyal, let me come to you first. Take us through the highlights of this landmark ruling and how it really puts a specific number on the threshold which had earlier lacked clarity.
Well, essentially, it will be the first legal precedent that will be set in terms of defining what really substantial is, following the retrospective amendment that came in 2012, where it was pointed out that Indian tax authorities has jurisdiction over indirect transfers that would be of substantial value. Now, what really was the substantial was the question that was there before the Delhi High Court, and it is addressed in saying that 50% of the threshold limit is what substantial defines for Indian tax authorities to tax the indirect transfers. Now, essentially, they have taken, the Delhi High Court really has relied on the views of Parthasarathi Shom Committee, remember, which is something that the government asked the Shom Committee to look into on the indirect transfer, but has been lying in cold storage ever since. But the Delhi High Court took into consideration what Parthasarathi Shom Committee said, and also what DTC, or the Direct Tax Code of 2010 version, was, where it was recommended that 50% of 50% should be the threshold to define substantial. And of course, the UN and OECD was also something that the court looked into to decide that that this is what the threshold limit is. This is perhaps the first legal case that has been addressed in the court to really understand and define the substantial value for the transfers, and therefore to decide as to which kind of indirect transfers will come under for taxation or under the Indian jurisdiction or not. So therefore, the first precedent really they're coming in from Delhi High Court through this ruling.
Let's take a step back. What was the specific transaction in question here, and what argument did the tax department make in deeming the transaction taxable?
Well, essentially, it was a global acquisition of Copal Partners from Jersey to Moody's, and Moody's had taken over that, was looking to acquire Copal Partners. Now, apart from this entire global deal, Copal subsidiaries included the Copal India and Copal Mauritius, which had an Indian subsidiary, Exquivo India, and that essentially was the bone of contention as far as this case was concerned. It was a three-step really the deal or the transaction that was there, wherein the control of Indian entities, the Indian subsidiary and the Mauritius subsidiary, which had an Indian subsidiary in its control, went to Moody, and that of course was routed through the shares being transferred from share being transferred from Copal Mauritius to Moody, Cyprus, and so on and so forth. Now, essentially what the IT department really pointed out and said was that these transactions were designed and carried in a manner in which there was a question mark as far as the tax avoidance is concerned. And remember, that has been a long debate on whether tax avoidance versus tax planning. There have been several cases that have been looking into that. And what the court, what really the IT department also pointed out, that given that there is no law of the land which is defining what substantial is, this indirect transfer also comes in under their ambit in terms of taxability, given that these entities of Copal are being taken over by Moody and in this indirect transfer.
Even as this comes as a landmark judgment, there are still a lot of areas of concern because the new DTC doesn't come into question here. And there are some areas of concern that there might be some discrepancy between this landmark judgment versus what the new DTC has to offer.
Well, essentially, Anu, the question will remain in terms of essentially what happens now. That, of course, currently with this order, that there is a precedent that is been set. Having said so, there is, of course, a DTC which is looking to be reworked at, and therefore that's something whether they will take into consideration the view that the court has really held, or there is some other legislative changes or clarity that may emerge remains a question mark. The other part, of course, that experts point out is that, what really would define as the value to decide on this substantial, whether it will be the shares, the revenue, and so on and so forth. So what really would be determining the value really of the assets, and also, of course, the big question that will remain, and something that the investors were really expecting in terms of this entire question on the constitutional validity of retro amendment. That, of course, is not part of this case, and therefore there are other cases that remain that are going to address the overall move of the retro amendment of the government, which had the huge impact that India has seen ever since.
All right, Gaurang, come into this, because FIs were really hoping to hear from Arun Jaitley in the budget to take the retrospective fears away, but no such luck. All cases now going to a committee.
Well, yes, this issue of retrospective taxation really came into the mainstream with the Vodafone tax case. Now, in 2012, the government retrospectively amended the tax laws to create what is now a rupees 20,000 crore tax case, which is currently under arbitration. Now, in his budget speech of 2014, the Finance Minister Arun Jaitley said that his government is committed to not create any new laws which would result in a retrospective tax liability. Now, since then, the government has also said that they would set up a new retrospective tax committee to look into all cases where issues of taxation arising out of retrospective legislation come into play. So now, experts have since then raised certain concerns with regards to how effective this committee would be. For instance, one concern that has been brought in is really that this committee may not have the power to directly direct tax authorities. Another concern which has come in is also the ambit of these cases and which particular cases could really be looked at by this committee. Now, we've heard from the Department of Revenue sources that the creation of this committee is imminent, and it could be notified within the next week itself. So what really remains to be seen is what the terms of reference of this committee could be, and how powerful and how effective really it could be as far as disposing of all these cases with regards to retrospective taxation are concerned. Back to you.
But that's for cases yet to come up. What about the millions of cases that are stuck right now, and some of them involving really large MNCs? Ashpreet, take us through some of those litigation battles currently ongoing.
But yes, after the Vodafone tax tussle, there were several cases which were filed challenging the constitutionality of the retro tax notices or amendment which was brought about. In fact, Azadi Bachao Andolan, McDowell are some of the big cases which have been reported and talked about so far. But other cases include the Sab Miller case in Bombay High Court, which was challenging the retro amendment. In fact, 2 show cause notices were sent or issued to Sab Miller by the IT department. McLeod-Russell in Calcutta High Court is also challenging the same issue. But what got IT department's attention here was the McLeod-Russell's 2005 buyout of UK-based Borelli Tea Holdings, which in turn held 74% stake in Williamson Tea Assam Limited. Other cases also which are pending in the Supreme Court, especially the Sanofi tax case, which is seeking a 7-member bench, that is a larger bench, to decide whether retrospective amendment can be brought about or not, and tax notices can be issued on this or not. Also, another case was the review of tax avoidance versus tax planning, which includes the Vodafone and the Azadi Bachao Andolan case. Kane was also pending in the Delhi High Court, where Kane had withdrawn its plea in the Delhi High Court, saying that since a special committee has been formed by the government in this budget, they would like to approach the committee and then see whether it can be resolved there and then. But it is not known whether the committee will look at older cases or not. So we'll still have to wait and see how are these cases decided by the courts. Though Delhi High Court has given this order, there are still chances of it being challenged in the Supreme Court and then the case reaching its finality.
All right, time for a break on Political Capital. Coming up, we discuss the implications of this landmark case and ruling with two international taxation experts, Sunil Jain of J. Sagar Associates and Shreya Rao of Nishit Desai Associates. Welcome back to Political Capital. The Delhi High Court has defined the threshold at which an indirect transfer of assets will be deemed substantial. Does this bring the much needed clarity on the taxability of such transactions? Priyal has been getting us those details. Joining us to discuss the implications as well, Sunil Jain, partner at J. Sagar Associates, and Shreya Rao, senior member of the international practice at Nishit Desai Associates. Sunil, let me start with you. Do you think in some way this brings in, as we've been discussing, the much needed clarity for a lot of these companies that are currently embroiled in litigation?
Well, there are many dimensions to the indirect transfer taxation regime that we have in India right now. There is an issue of retrospectivity that has been provided in Section 9 amendments. There is an issue associated with constitutional validity of that retroactive provisions. Then we have certain issues around how do we value such transactions, as to how do we look at the substance valuation in India before you are going to tax a transaction that actually gets consummated outside India. So those are the few buckets of disputes and lack of clarity that are there, in relation to which judicial determination will be more important until we have some administrative clarity in relation to how computations need to be made. Now, this judgment obviously does not address the issue of retrospectivity or constitutional validity. That was not the prime issue of controversy in this case. This case pertains to whether the substance that is there in India and the series of transactions that were consummated outside India, whether there is an interface between the two, and then whether the substance that is there in India is subject to taxation in India. Now, based on the series of transactions, the tax department wanted to assert before the tax judicial forums that some of the transactions of which are little closer to India needs to be overlooked, they need to be disregarded because they were primarily designed for tax avoidance, and that a transaction which was consummated at the apex of the structure is a transaction that needs to be looked at, and then there is an indirect transfer, and that the transaction majorly derives its value from assets located in India. Therefore, the center of the controversy became as to what is the substance here. And since there is no clarity or no administrative clarity in either the provisions or by circular as to what will be substantial, some reliance has been placed on OECD and UN model, and also the Shom Committee report to finalize that a 50% threshold is something that is critical in relation to analyzing whether transactions are taxable in India or not. Now, clearly, for all the transactions that are already on the radar of the tax department and all those that will come into picture on a prospective and a future transaction basis, there is some amount of clarity that 50% could be the threshold. But as pointed out by your team, we may not have seen the end of this controversy, and the tax department may choose to escalate the matter right up to Supreme Court. We do not have clarity from the tax departments whether they also accept the 50% threshold. The March 2013, the latest DTC draft that is there in the public domain talks about 20% as the threshold, which will mean, virtually imply lot many transactions that will come under the radar of the tax department as indirect transfer is concerned. So much clarity has been provided in relation to existing transactions, but we need to hear the view of tax department to be certain.
Shreya, come in on this. What I'm hearing from Sunil is that this might be a landmark judgment in a way that they've finally put a number to that of 50% threshold. But the area of concerns, as Priyal was also mentioning earlier, are far larger right now.
Yeah, I would agree with that, and I think one of the most important facts about this case is that it isn't a case that relates primarily to the indirect transfer issue. And I think some background would be helpful over here to understand why this transaction was structured the way it was. Now, what happened is that there were primarily 3 transfers. And out of the 3 transfers, 2 involved transfers of Indian entities and a third involved a transfer of a global entity. Now, at the point when the advance ruling, the revenue made arguments on the advance ruling, they did not argue on whether there was an underlying avoidance motive to these 3 transactions taking place. And at the point when the writ petition was filed, they argued that the reason this split up was the way it was done the way it was is because there was an underlying avoidance motive where the parties were trying to segregate the Indian entities from the global entities. So when you look at what the High Court has ruled on, the primary issue it has ruled on is whether there is avoidance. And it has all of its observations on the indirect transfer tax issues are only secondary observations where they have said that because the revenue has based all of its arguments on the assumption that there is underlying taxability in India, we are considering the indirect transfer issues. So from a legal interpretation perspective, these don't carry the weight of binding law. They would be judicial dicta which still have very strong persuasive value, but they are not binding law. So I think as far as the law is concerned, we would still need to wait for the High Court rulings on core constitutionality. So McLeod, Russell, Saab, Miller and all of these other cases which are pending for the law to change. Having said that, subsequent High Courts, when they look at these issues, are likely to give very strong weight to the very lucid judgment that the Delhi High Court has given on substantiality.
That's a very important point, Shreya, that you're making. And if I were to understand a little more on that, 2 questions that I have for you. First, so you're saying really is now that when the tax authorities are going and weighing the indirect transfer, and there is a question on other cases whether they're taxable or not, when there is a gray area or substantial on the issue of what really constitutes substantial, you think that this will only be acting as a judicial sort of reference, a strong reference there, but there will not be any specific binding point that the IT department really will be looking into in terms of understanding various indirect transfers.
No, I think, well, as far as the first High Court ruling on the subject, it definitely carries very strong weight. But at the same time, it wouldn't be the same as a ruling on the direct issue of indirect transfers. Because the core issue that the parties were looking at in this case was whether there was avoidance. So the court has looked at indirect transfers only as an afterthought.
All right, Sunil, let me get your thoughts also on this in terms of understanding as to how do you see this will have implication on really the IT department deciding on various such cases that are there before them. But the important point now here also one has to remember is that with this budget there has been also this whole debate of the high powered committee really coming into picture which would be looking into indirect transfer. Will this, ruling of the High Court and their observations as far as the indirect transfer is concerned will have a precedence or at least have a bit of an understanding in that sense for the committee to look into it?
Right, exactly. Out of the many issues that the committee looks at in relation to past transactions, because obviously future transactions there is no uncertainty as such, apart from the valuation issues as I mentioned earlier in the program. The committee now have some clarity that based on existing literature that was much publicized, like the draft Direct Taxes Code of 2010 and also the SHOAM committee, that the judicial forums have also now come to a conclusion that the 50% threshold is what will define substantial value being derived from India. Now, we have no clarity as to whether the present dispensation also subscribes to the view given in the latest March 2013 DTC, where the threshold has been reduced to 20%. We understand that the present dispensation is looking at the whole issue of direct taxes code in a much more open-ended manner, and that they are going to look at whether the iterations available in the public domain so far in relation to direct taxes code actually serves the purpose or not. But clearly, they will now feel a little bound by this 50% scenario, and in a certain sense, this High Court judgment will also exercise them in order to finalize their strategy as to what they would like to imply this substantially value derived from India to be. And I think some kind of administrative clarity should be provided by the tax department, because in case they choose, as you pointed out, to fight this case in Supreme Court, then clearly they are looking at, apart from the other issues in the judgment, striking at whether 50% is the right threshold, and in arriving at the conclusion that it did, whether High Court has rightly relied on international literature like OECD and UN manual and the Shom Committee report, because government has never clarified its stand on this. So therefore, we now have an occasion for everybody to arrive at a consensus, and rather than solving this problem at the judicial forums, we should actually be waiting for an administrative clarity, because that will not only clarify the tax department view, would also in future tax litigation prevail upon the judicial forums which will analyze this judgment, and in that total scenario there will be much more certainty.
And in that case, Sunil, would you agree that probably the Shom Committee report is something that needs to be at least seen or decided upon, whether the government needs to do something about, because you've done your reports, there are other, provisions that have been looked into. You have, constituted a committee to be looking into it. So there needs to be that, it coming out of the cold storage. Do you believe so?
Absolutely. We have a problem with, lack of continuity in relation to various committees' recommendations that are made on a particular subject. Before constituting new committees and before arriving at new conclusions and new thresholds, we clearly need to look at good amount of work that has been done in the recent past on this issue. And there are a large number of, helpful clarifications provided in the Shom Committee works that were put into the public domain, and there are a number of issues that can be settled in a very amicable manner should the government chooses to actually implement some of the suggestions provided by the Shom Committee. 50% threshold is clearly one of them.
Shreya, let me bring you in here, and you started with the whole question with the High Court also looked into the tax avoidance issue, and tax avoidance and tax planning is something that has been debated across various cases. We understand, and of course that the department is also in the ongoing Sanofi case in Supreme Court had sought that probably the government, the Supreme Court rather, constitutes a larger bench and looks into this whole issue that has been going on. How critical do you think it is for the courts, or some clarity emerge in terms of setting the parameters as far as what the difference between the tax avoidance versus the tax planning debate that is going on?
No, I think there's some hugely positive holdings by the Delhi High Court in this case. Aside from the indirect transfer tax issue, one is that they have reaffirmed the availability of tax treaty benefits to the Mauritius route. And in that sense, they have said that, that they recognize that even though there may be companies which are managed from outside Mauritius, that treaty benefits should still be available to those entities. And there's been a lot of apprehension surrounding Mauritius over the last couple of years. And in fact, I think a few months ago, the FDI from Mauritius dropped to the lowest in almost a couple of decades. And while that's slowly seeing a rise, I think investors will appreciate this greater certainty that the Delhi High Court has brought in, which is one of the points of this case that's not so much discussed, but it's likely to be very significant going forward, particularly with the GAR looming ahead and the GAR expected to be enforced from next year on. This is a very positive aspect of the case.
All right, Sunil and Shreya, thanks for joining in, Priyal, for all those updates as well. A lot of clarity still awaited from the tax department despite the landmark judgment coming in from the High Court. That's all we have on this edition of Political Capital. Thank you for watching.